Hi, this is Keith Davidson from Albertson & Davidson. In this video, I want to talk to you a little bit about the duties that an executor has in California. So if you have a will, or if you have a decedent dying without a will, their estate must go through probate, which is really just a court process where the court oversees the transfer of assets to the beneficiaries under the will or to the heirs at law if there's no will. And there's a lot of duties that an executor has in a California probate, but there's 6 main points that I want to at least make sure you're familiar with if you're going to be an executor or if you're a beneficiary of an estate and you want to make sure your executor is taking the right actions. The first thing that an executor must do is take control of the estate assets. So they have to go out and collect all the assets and safeguard them, put them into new bank accounts in the name of the estate, and make sure that everything is safe and collected. That's called marshaling the assets. And so the executor has to go out and marshal all of the assets and make sure that they have control of the estate assets. The next thing the executor has to do is they have to do an inventory and appraisal of those assets. So they have to list out every asset that they came into possession of, and they have to have those assets appraised. If the asset is cash, the executor can appraise that themselves because cash is cash. But if the asset is anything else, like real property, stocks and bonds, jewelry, they have to send that out to the probate referee and get a formal appraisal of those assets. And then that inventory and appraisal has to be written down on a form and submitted to the court and handed out and served on all the beneficiaries so everybody knows what assets are part of that estate and what assets that executor is going to take control of and manage. The next thing the executor has to do is notify creditors. So one of the main reasons why we have probate in California is to protect creditors. And so everybody who is a creditor of that decedent, anybody who is a known creditor, must receive notice from the executor that the estate has been opened and that the creditor has a right to file a claim in that estate. And that has to be done within a certain amount of time after the estate is opened. And then every creditor has 4 months after letters are issued, after the probate starts, to be able to file a creditor's claim with that probate estate. The next thing the executor must do is ready the estate for distribution. So if there's any assets that need to be sold or dealt with in any way, if there's any legal claims that need to be litigated, the executor needs to make sure all of that is done, because eventually the assets need to be gathered together and distributed to the beneficiaries. And so all of those management issues need to be taken care of before that time. The next duty the executor has is to provide an accounting to all the beneficiaries. And every executor is required to provide information and an accounting to the beneficiaries unless the beneficiaries voluntarily waive an accounting, which sometimes does occur in certain situations. But the executor should keep very detailed records of all actions taken for the estate, because chances are an accounting will be required. And finally, an executor has to close the estate and actually distribute the assets out, give the assets out to the beneficiaries, and that's the final step of probate. And once those assets are passed out to the beneficiaries have to sign a receipt acknowledging that, yes, I did receive the assets that were meant for me, and those receipts are filed with the court, and only then is the executor relieved of duty and no longer required to act. And so those are the 6 basic steps that every executor must take for a California probate.